Welcome to Looking at Legal Stuff. Today we have 14 hearings in a case with a couple where dad is extremely worried about mom's new boyfriend, who has a lengthy criminal record and is a registered sex offender. He doesn't want this guy anywhere near his children, but mom is allowing him to live with her. The guardian ad litem is also concerned about this man being around the boys, so much so that she recommends that dad be made primary parent and mom only have visitation. She doesn't think mom understands how risky her choices are. Despite Mum's claims that he will never be around the children again, we return to court for contempt after contempt brought by Dad when he keeps finding proof that she continues to lie about this man not being in her home or around the boys. Mum claims that her boyfriend is never there when the children are, and any evidence that he has that shows differently has been faked by her neighbors, who she claims are giving Dad this bogus evidence in an attempt to harass her. What will the court have to say about her hard-to-believe claims? Let's find out.
Next matter I have is Jeffrey Bierbauer and Ashley Bierbauer, 233-1308 is the cause number. And Jeffrey Bierbauer, are you on the line today?
Yes, Your Honor.
Okay, welcome to you. And Ashley Bierbauer, are you on the line today?
Yes,
Your
I am.
Honor,
Okay, great.
I'm attorney
Mr. Hawkins, you're representing
Yeah, yeah.
Bierbauer, correct?
Sorry, what was that? I'm here as well.
Yes, yeah. Yeah,
Awesome.
thank you. No, it's good to have you here, Mr. Hawkins. I note that you're representing Ms. Bierbauer. And I
Yes.
see that Ms. Powers is here representing Division of Child Support, and Ms. Height, the guardian ad litem, is also present. My notes indicate, and I prepared for a guardian ad litem report that was submitted. Let's see, actually, yeah, it was submitted, and the recommendations were made, and we're here for that review. So let me just, before we go further, there's an Alexandria Vaughn that's on the line from the hearing that just concluded. So Ms., I just want to just give her a brief update of what happened as she was not able to connect. Okay, thanks for allowing that pause. So Ms. Height submitted her report related to parenting plan and the like related to Mason and Hunter. I'm assuming that all parties have received a copy of that. Mr. Hawkins, did you receive a copy of that?
Yes, I did.
Okay, great. Mr. Bierbauer, did you receive a copy of that document?
Yes, I did.
Okay. And let me just double check with Ms. Powers. Ms. Powers, as far as your interest, your client's interest today, do you have any input related to the guardian ad litem report? Is it more related to what the outfall may be from that and its impact on child support?
Correct. No,
That-
it's just taking in the information.
Perfect. Okay, great. That sounds great. Okay, so with that, maybe Ms. Height, if you would like to lead out, it sounds like all parties, including the court, has received and reviewed your document, your report. So if you want to just give it just a brief over of maybe some high points, and then we can just hear from the parties.
Thank you, Your Honor. I did meet with the parties and significantly with the boys. And we had a good visit. They seemed happy and comfortable, and they seemed to be pleasant when they talked with about both households. They didn't voice any particular concerns or fears at either one. They both were very clear that they were never alone with the boyfriend that has been of concern because of his criminal history. And that had been one of the court's main concerns before. I was able to speak with him and with Mr. Williams, and he also said that he is very conscientious about being always with someone else if the boys are around, and was very clear about understanding that was important. I do know there's more information that I need to figure out about the boys, especially as far as their housing situation, their schooling situation, and it's such a short time, and it's only May 4th until the final report. So it seemed to me prudent not to anticipate any kind of change, which I am currently not, ready to say anything like that. I don't want to give either party the impression that I'm thinking about that, but just merely noting that the idea of making a change with the possibility of moving it back again in another month, it just seemed incongruous for the boys at this time. So my decision to recommend that we leave things as they are was basically because I didn't feel that the boys were in any kind of peril, and also that we are coming up on another review in a couple days less than a month.
And that date, that further review has been set. Is that accurate?
My understanding is it's set for May 4th.
Okay. Okay. All right, Ms. Hyde, thank you. I appreciate that overview.
One other quick question was, when I spoke with Ms. Bierbauer, she has been attempting to get county pay for her portion of my fees, and she has so far been unable to get the paperwork completed, and she assured me that that was done. I did not look at Odyssey this morning before court to see if that was done, but that does need to be taken care of, and she indicated she was on board to do that.
Yeah, it looks like on April 4th, there was a orders filed, order waiving guardian ad litem fee. The court received a motion to waive the fee from the respondent, which is Ms. Bierbauer. Court made a finding that she's indigent, and the court granted the motion to waive the guardian ad litem fee. So it'll be a county pay.
Thank you, Your Honor. I appreciate that. I had not checked that this morning, so I appreciate you letting me know that.
Okay, thank you. Mr. Hawkins?
Yeah, we really don't have much to say. We are in support of maintaining the status quo for now, and we would reserve our and any quibbles we have with the report, we can wait until the full report comes out.
Okay, all right, thank you. Mr. Bierbauer?
Yes, Your Honor.
Do you have any input related to the recommendations of Ms. Height? Or-
No, I do not. I'm in agreement to wait till the 4th.
Okay, okay. All right, well, I appreciate Ms. Height's investigation and input related to the safety of the boys. You know, the key words, at least I heard today, were the boys are not in peril, and that there are I think it's Derek Williams is the boyfriend, has not been left alone with the boys. I think that's very important to know, and hopefully that definitely continues. That sounds like very important. So those same prohibitions will remain until the next hearing, which are that Mr. Williams is not to be left alone with the children ever, and that the boyfriend is never responsible for their care. So it'll have to be somebody else. And at this point, there'll be no change. It looks like the date is set for May 4th, so we'll move it to that date, and we'll have potentially more information regarding housing and education of the boys from Ms. Height, and we'll review that at the next hearing.
Your Honor, might I just add one thing?
Sure.
I noted in my report, and I'm sure Your Honor saw it, that there were a couple of times in my conversation with the boys that they seemed quite concerned about their dad hearing something, like they were afraid for him to know. Like I didn't pursue it, but I got the impression that they perhaps had been told to keep secrets, or they were privy to information that was inappropriate for them to know. And I would just appreciate the court reminding the parties that the boys should not be privy to conversations about this parenting plan or my GAO report or other things that are going on in the family that are adult issues. It was pretty evident that there was something there.
Yeah, I appreciate that friendly invitation. I had a similar impression when I read that report. The impression that I had when I read that report is that these are pretty innocent, sweet little guys. And when they say something like they're kind of express a concern of like, oh my gosh, did dad hear about that or something like that? Then that's just kind of pure, and it just kind of comes out. So yeah, that's really important. I think sometimes adults, we inadvertently do things that involve children in very adult issues because little boys absolutely love both their mom and their dad. It's so hard to distinguish, to be pitted one against the other. And in their mind, they feel sometimes that that's required of them, and that just rips them right down the middle. And it's very unfair. And I think hopefully I'm preaching to the choir on this, that any adult conversations related to the boys should be heard out of earshot, so they're just not exposed to that their life can just be as pristine and happy and bubble-like, if you will, as this case moves forward. So just that's a friendly and important reminder to safeguard and protect those boys from adult conversations related to the parenting plan and any issues between the parents. So
Your Honor, can I say something?
sure.
I do not discuss what's going on between me and Ashley with the boys.
Okay.
They're at the age that they really don't need to understand that right now.
Yeah. Yeah, and that's why I kind of led off with my comments that I think sometimes as adults, we inadvertently do things that we may not be completely conscious of that may send a message, or the kids pick up on a message. And so just a heightened sense of awareness for all, just to be on our top of our tippy toes to safeguard those little guys. Good, appreciate that. So I think we decided we would set the matter over to May 4th. And if there's no other issues, we'll leave that date set and conclude today's hearing.
All right, thank you, Your Honor.
Thank you, Your Honor.
Thank you, Ms. Height.
Thank you all.
Thank you.
Any other parties seeking a continuance? All right.
Your Honor, on number 8, I just want to check with you that we filed a declaration yesterday. Today we have we received the GAL's report last week, and I just want to be sure that the court has it. And I understand that we sent this last night to the other parties, and I don't know if they've had time to review it.
So is
I
this
think
on,
there may be,
this on Beer Grower?
yes.
Okay. And are you an attorney for one of the parties?
Yes.
Who do you?
Respondent.
Okay. All right. I have seen the GAL report. I know Mr. Beerbauer is here. Have you seen the GAL report?
Yes, I have, Your Honor.
All right.
And I haven't received anything from Mr. Hawkins.
Okay. Because that's my issue, Your Honor, is that we filed a response declaration yesterday. We got the report last week, so we've been on a little bit of getting it in. So I think if Mr. Beerbauer hasn't seen our response, then maybe we should set this over. And if the court hasn't seen it.
Mr. Beerbauer, any response to that?
Like I said, I have not received anything from Mr. Hawkins. If he sent it out last night, it's going to take a week to get here.
Yeah.
I believe we tried sending an email. Were you able to receive the email?
What email did you send it to?
Let me check real quick. It's Jeff.
I have not used that email in probably 3 years.
Sure, that's understood.
Let me do this, Mr. Hawkins. Do you have a business phone number?
Yes.
Do you want to give that to Mr. Beerbauer?
Yes. It's 36. Oh, sorry.
Go ahead.
360-605-1000.
Mr. Beerbauer, if you would call Mr. Hawkins and maybe give him some updated contact information. I don't want you to do it here because we're streaming to YouTube.
Understandable. But Ashley does have my phone number, and she could have given that to Mr. Hawkins to have him contact me.
Okay, well, if you could give him a call when we're off today. So typically when I know the guardian ad litem report was just filed. I understand a response to it by yesterday. It's probably makes sense. And everybody should have that so that we can all be on the same page. Let me hear from Ms. Height. I know what your report said. Do you have any issues about putting this over 1 week? You're muted right now, Ms. Height.
Sorry, Your Honor. I understand the need for everybody to have the
response, which I was able to get this morning. However, as Your Honor can see from my report, I have some very heavy concerns. And I would like, if it is your intention to set this over, that it would be set over as short a time as possible.
I was only gonna go over 1 week
Okay.
to this docket next Thursday.
Understood. Thank you.
Okay, I'm not gonna make any changes in the visitation arrangement, the living arrangements at this point. I want to be able to hear from all of the parties and fully from Ms. Height before I make those decisions, okay?
Mhm.
So, all right, so we'll put this over to next week. Let me give you the date on that. I think it's May 11th at 9 o'clock. And we will
Okay.
proceed from there. All right, thank you, Mr.
Thank you, Your Honor.
You're welcome. Thank you.
Filed by Ms. Bierbauer, so I'm gonna give everybody a chance to discuss with me what they'd like to see going forward. And maybe what I should do is let Ms. Height speak first, and then we can respond to her, okay? Ms. Height?
Thank you, Your Honor. I filed my report after my investigation, and I guess the most cogent way to start would be to say that at the end of my report, I make the statement that I'm tasked with answering the question, what is in the best interest of these children? And further to say that I understand that this is a major change for this family, and that it's going to be upsetting probably for everyone involved. But I feel like this report reflects accurately my reasons for considering a major change of residential time. I think the concerns that I talked about in there, basically swirling around the home setting with Mr. Williams in it, are of such concern that it seems like that is going to be the best. My recommendations of changing primary residential time is going to be in the children's best interest. And I don't know how much, there's quite a lot there. I don't really want to go into every bit of it. If there's a listing of things there that everyone's been able to see. I guess I want to acknowledge that I know this is difficult, and it was a difficult report to write, and it was after a lot of consideration that I came to this point. Once I got there, it feels like it is definitely in the children's best interests. A couple of things have come my way unsolicited since then. I've had 2 phone calls from a neighbor who was quite reluctant to talk to me for fear of some kind of blowback. This neighbor very vividly described hearing, she recognized which child it was, who was saying she could hear through the wall him hollering, no, stop, someone please help me. And she called me wanting to know what she should do about that. And it had had already stopped. It has ceased. It was something that had happened, I believe, from my notes on April 27th. And so my statement to her was, if you feel like there's something going on that is endangering to a child, then you need to call law enforcement. At that moment when I was talking with her, nothing was going on. But she said that she has heard a lot of upset there. And that was concerning and sort of verifying to some of the other mentions of Mr. Williams hollering. She said that's who was yelling at a child. So that kind of underscored the things that I had come to believe would be in the children's best interest. In addition, in also, which I had a copy of, a statement in writing that Ms. Bierbauer said about Mr. Bierbauer. I'm reading from page 3 of temporary parenting plan from 2016. Jeff has always had a loving relationship with the boys. And then further down, Jeff keeps the children safe and protects them. So while I recognize that he has had less opportunity
to care for the children and be involved on a day-to-day basis due to the current parenting plan. I do believe that he's capable of doing it. He's willing to do it. He has support system in place. So that's on one side. The other side is Mr. Williams is very enmeshed within the family. When I saw them together, he is helping out with schooling. He's correcting the children. I believe that I described some of that for your honor. He is definitely a very important part of the household. And I find that because of his past and because of the short time that he has been around, that I am not confident that he is a safe person or that that household is safe with him in it. And in fact, you'll note that I don't believe that he should be present during visitation with mom. So that is kind of in a nutshell where I landed and why I did. And I would reiterate to you again, I understand that this is a big change, but my concerns rose to the level to recommend that change.
All right, thank you. Mr. Bierbauer, anything you would like to say?
Not really, but on like the past is my past, as what Ashley has stated in the report from 2016. That's done. It's over with. I'm more worried about the present and the future and the safety of my children.
Mr. Hawkins?
Yeah, I would just like to talk about three things. The first is what the report didn't consider and what we addressed in the response is that there have been instances of prior abuse from the petitioner, including accounts of rape, one which took place in earshot of the children. All of this resulted in a restraining order. And from what I understand, the petitioner has not denied any of these allegations at this point. And so it's concerning to us, and especially highlighting what Mr. Bierbauer just said, that he's not concerned about the past is behind him, he's concerned about the present. And we find it interesting that you'd be holding the past against my client's boyfriend and not considering his present state while not doing the same for Mr. Bierbauer. We'd also just like to note that in regards to concerns about schooling, in the response we noted that they are on track with their 12K online plan. And to the second point, I think this is not in the best interest of the kids. Like I very much respect Ms. Height and the report she put together, and I understand the amount of time and effort that goes into this and how hard this can be. But we see this as a massive upheaval that disrupts their schooling and their social lives. And petitioner has not yet shown the ability or willingness to perform these daily tasks for the kids. And given his work schedule and the needs of the kids, including medical appointments that are every 2 weeks, every 2 weeks with a counselor, every month with a psychologist, and other regular appointments, we do not feel he'll be able to provide for those. Along with just the daily needs of taking the kids to school and picking them up from school and providing the care that's needed there. I don't think we have an idea of what kind of plan is in place to fulfill that. And so I think we seriously doubt whether that can happen. And third, I would just point out to this first point again of there are current precautions in place with the mom living there. Currently, the boyfriend is not seeing the kids on his own. He's not being there alone with the children. And additionally, as Ms. Height noted, there have been no allegations by the boys nor any whispers of impropriety going on there. And so I just think it would be in the best interest of the kids to maintain this status quo. And I respectfully understand these concerns, but I think the concerns of making this change are equal to those. And so it doesn't make sense to me to make any change at this time.
Okay, you have it she had it listed that I work 5 to 5. I do not work 5 to 5. I'm usually off work by 3, 2:30, 3 o'clock, 3:30 at the latest. And she knows that. And on the medical stuff, I have asked her actually numerous times to let me know. And she does not inform me. She has not asked me to be to them in over a year and a half since we've been separated. I
Hasn't asked you to do what for them?
To go to any of the appointments,
Okay.
the medical appointments, and she has not informed me of any of them.
Okay.
And I have my father here that can pick them up or drop them off and pick them up at school. And I can pretty sure I can get time off to take them to appointments.
We just like to again repeat that there is concern over the regularity of the appointments needed. It is not conducive to that kind of work schedule. And so just asking for time off seems not a workable solution. Again, when historically that hasn't been the case. And again, historically, my client has asked him to be involved and he has not been. And I think that leads to this pattern of not asking now because
Okay.
he has shown a lack of interest before then.
I have no text messages or phone calls from her letting me know when appointments are. None. I save all of her text messages and phone calls. I do not delete them. I have none.
All right. Ms. Height outlines the criminal history of Mr. Williams, starting in 2008 with rape in the third degree, child molestation in the third degree, and rape of a child. That was in Cowlitz County. And it goes on until 2019 was possession of a controlled substance, 2019 unauthorized use of a vehicle. Apparently in 2019 was the failure to register as a sex offender where he resulted in 3 years in prison. And there is no criminal history, I guess, after that, which is likely because he was spending that time in jail. And my understanding is he went directly from jail when he got out after 3 years into Ms. Bierbauer's house. And is now, as Ms. Height said, integrated into that household. So the first thing I want to say is that the criminal history isn't ancient. It's up until what I would consider present day. And it is a history that the father is legitimately concerned about, and Ms. Height is legitimately concerned about, and the court is legitimately concerned about. So that's the first thing. The second thing is I want to tell you how I viewed this case. Making a major change for the children places the burden on the children. What's going on here is we have somebody with a very concerning criminal history, and I think a mother who made a bad decision to bring this person into her household with her young children. The burden of that should rest with Mr. Williams and Ms. Bierbauer, not with the children. And I think the way that that gets handled is this. I'm going to do this in two time frames. From now until June 15th, which is just for my purposes, the beginning of a summer, I'm going to leave the same schedule in place. So the father will have the children, I think, every other weekend. But Mr. Williams must be absent when the children are with the mother, which means he's going to have to find somewhere else to live. If Ms. Bierbauer wants to spend more time with Mr. Williams at the house, then the children can go to Mr. Bierbauer more often. But Mr. Williams must be absent from now until June 15th when the children are at Ms. Bierbauer's house. Starting on June 16th, which is a Friday, I'm going to order that the children spend 1 week with one parent and 1 week with the other parent. And so that first weekend, the transfers I'm going to order are going to be Fridays at 5. So June 16th at 5, the children will go to be with the father and will stay with the father the next week. And that's going to be the schedule during the summer. Again, the week the children are with the mother, Mr. Williams cannot be there. I'm going to order a review hearing on August 24th. And the issues at that hearing will be what contact, if any, the children should have with Mr. Williams going forward. Second will be what kind of schedule between the parents we should adopt. And third will be what kind of schooling they're going to receive. I think transferring the children to Mr. Bierbauer and having them enrolled in school for about a month with special needs kids strikes me as being pretty disruptive to their lives. And that's why I'm not going to order that. However, if I'm not convinced that there's a good homeschool program put together by Ms. Bierbauer, which will include testing and evaluation of the children, then I may well place the children with Mr. Bierbauer starting next school year so that they can attend school where he lives.
And I have the paperwork to enroll them in school. I have it filled out. I just have not turned it in yet.
I'm going to give Mr. Williams, well, is this your weekend, Mr. Bierbauer?
Yes, I will pick them up tomorrow at 5 o'clock and bring them back on Sunday at 5 o'clock
All right.
at the Fred Meyer parking lot.
I'm going to order that Mr. Williams needs to be out of the house by Sunday before the children come back. And if that's not possible, then there needs to be a message to Mr. Bierbauer that he should keep them until Mr. Williams leaves.
Oh, okay,
And let
so
me-
he's allowed to be there until, okay.
He's
ahead.
going to be there tonight and until you pick him up tomorrow. I don't know that that process can work faster than that, but he needs to leave by Sunday. All right. Let me go around. Ms. Hyde, any questions about that?
No, I don't have any questions. I would just like to comment on the schooling. I felt exactly like you did, as you just stated, that it would be very disruptive. And I spoke to a special needs master's level educator about what options would be best. And in fact, it surprised me that this person said that they felt like having the kids go have some time in school for a short term as kind of a transitional time and then going into summer would actually be in their best interest. So I was surprised to hear that, but that's why I included that in my report. That was from somebody who is a pretty high level expert in the field. So I just wanted to drop that information in.
Part of what entered into my thinking here is the children have been with Ms. Bierbauer for their daily care for quite some time.
Correct.
And I view the week on, week off as a transition time if we need it. So
Oh, yes, I think I understand and appreciate what you're doing. I just wanted you to know where my thinking had come from on that.
thank you. Mr. Bierbauer, any questions?
Not right now, Your Honor.
All right, Mr. Hawkins,
Just can I get the date again for the review hearing?
will be August 24th. It should be a
August-
Thursday.
Okay.
I'm assuming school is going to start the first week of September. And so I want to have a hearing to determine what we're going to do at the beginning of the school year. And that would be a natural transition to look at the visitation schedule.
Okay,
Right.
so will that, Your Honor,
I
will
will,
that be via Zoom or in person?
that will probably be Zoom. I think we're going to be on Zoom for quite some time. Okay.
Right.
All right, I'll put a bench order together. Should be available by Monday, but again, Mr. Williams will need to be out of there.
Bierbauer and Bierbauer, 233-0001308 on for contempt. All right, this was filed by the petitioner in this case. There was a motion for contempt based on an allegation that on May 24th, 2023, the respondent and another individual were in a vehicle with the two children after the time frame that individual was not supposed to be around the children. Am I getting that correct, Mr. Bierbauer?
Yes, Your Honor.
Okay. And then I did also receive the response. So, Mr. Bierbauer, do you have any additional information or any argument you'd like to make at this point?
I didn't receive or know anything about a response information. I
Was
don't
it-
know if I was supposed to email that to me or I haven't got anything.
Mr. Hawkins, you're representing Ms. Bierbauer,
Yes,
and was that response provided to Mr. Bierbauer?
I believe so, but I'd also like to note that he never provided us his motion. We have never been served with that, and so I just wait.
That
Would
was
like to
an
note that for the
honest
record.
mistake.
And if not, we can send him the documents, but I believe they should have been sent to him.
Well,
I have not received any emails.
all right, hold on one second. Are both parties available next Tuesday afternoon?
Yeah, I have
That
to
would
take
be
time off
the-
work again.
20th at 1 p.m. Well, if you want to move forward without knowing what her response is, we can do that.
I don't know what the response is or anything because I haven't received anything.
I understand that. I'm
Through-
offering you an opportunity to review that before we move forward, or
Yeah.
you can move forward now without,
I'm available next Tuesday.
right? Mr. Hawkins, are you?
Yes, I am.
All right. Then let's set this over 1 week to the 20th at 1 p.m. And then if parties can make sure to get any information that you want to argue before the court to each other by Thursday, close of business. And it sounds like if emailing works best for everyone, given the tight time frame, then let's have it be that way so everybody knows what everybody's position is.
Okay.
All right.
Yara, would you ask Mr. Hawkins to please include me in any information he sends out?
If you could do that, Mr. Hawkins, it looks like you still
Yes.
have an active GAL in this case.
Yes, will do.
All right.
Thank you for
so
reminding me.
I appreciate your patience. Let's have you come back next Tuesday, the 20th at 1 p.m. And I'll try to, I'll make a note to get you called as quickly as I can at the beginning of the docket.
Thank you, Your Honor.
Later in the day is fine for me.
All right. All right. Thank you both. We'll see you next week. All right. Bierbauer and Bierbauer, 233-000-1308. And that is on for a show cause contempt that was filed by Mr. Bierbauer based on essentially a order that Commissioner Nelson entered in May, or was it April or May? Mr. Bierbauer, any additional information that you would like to provide other than that you've already filed?
Yeah, I've got 3 more.
3 more
My oldest,
contempts or 3 more?
yes, 3 more deals that I have found out after I had filed the paperwork. So Mason, who is my 10-year-old, come to me and stated that I'm the one that started the war between me and his mother, and that he's been video chatting with Mr. Williams. He told me that. I didn't ask him. And it states in the bench order that he is not to have any contact with Mr. Williams. That's 1. And number 2 is the neighbor reached out to me in regards to on her defense deal declaration. Her neighbor reached out to me for the safety and well-being of my children. I didn't reach out to her. And the neighbor has confirmed that Derek has been at the residence numerous times while he's not supposed to be. And the third one is when I had her served, Mr. Williams was at the apartment behind her at the door while her mother and the children were there.
And then I would like to ask a clarifying question. The contempt that is before me is, it indicates that contrary to the bench order that was entered, Mr. Williams was seen, or Ashley and Derek were spotted in a vehicle with the children on Third Avenue at 9:45 PM on May 24th. Who witnessed that?
It was me. They were at a stoplight as I was making a turn in my work truck to go back to my yard. I recognized the car. I recognized him driving. Ashley in the passenger seat and two boys in the back seat.
Okay. I appreciate that. Thank you.
You're welcome.
All right, Mr. Hawkins, good afternoon.
Good afternoon, Your Honor. I think we've pretty well stated what our position is, that these are just untrue and these continue to roll in. I do take exception that he's brought in 3 new claims of contempt when he had a chance to bring them up to me a week ago. He had a chance to bring them up. These predate our hearing last week when he still had time to file additional responses, and he hasn't done so. We provided documentation that shows when Derek checked into his hotel, there was no contempt for not notifying him about Derek being at the house, because Derek has not been at the house. And again, at the time he claims that he saw the kids with Derek, they were with their grandmother at the house as well, while my client was out doing visits. And I don't have responses to these brand new claims, but I imagine they're more of the same. These feel to me like trumped up charges of things that just aren't happening.
They're not trumped
And
up
I'm
charges.
Wait,
concerned. I'm
hold on,
concerned,
Mr.
Your Honor,
Bauer.
because the lengths that I'm concerned because he puts in like a single sentence making an assertion about these things without much more context. And in the same petition is requesting that my client go to jail and that a restraining order be put in place on behalf of his kids. It's just really extreme measures that he's trying to take over things that are hardly verified beyond a simple statement. And so we continue to believe there isn't any other factual evidence to show that anything that he says is true.
All right. Thank you. Mr. Bierbauer, anything else?
The one with when she was served was on the 1st of, it was 6/1 is when I had her served. So that was after I had filed my paperwork. Same with where Mason had told me we were actually out camping when he told me that.
I just want to clarify that I understand it was after you filed, but last week we met and you had a chance to file more by last Thursday, and you did not. And you chose instead to bring it up now.
Because it pertains to this court case.
All right. So a couple things. So Mr. Bierbauer, everything needs to be outlined in an actual motion so the other party has an opportunity to respond. So I think that's what he's referring to. These other 3 allegations haven't been outlined in a motion for contempt. That does not preclude you from doing that again if you wish to file another contempt. I'm looking at the bench order entered by Commissioner Nelson. Looks like May 11th. And I also reviewed the GAL report. I see Ms. Heights here. I don't know, Ms. Height, if you have anything to add. If you do, I'll give you an opportunity in just a second. What I do notice that's clearly very concerning and is the allegation, at least, of continued contact with Mr. Williams and the children. So as to the contempt that's before the court, concerning behavior, I see that the respondent, vehemently denies that, does provide receipts of being out on deliveries. Frankly, that doesn't necessarily show that the kids weren't with her. The text messaging to her mother doesn't say, I'm coming to get the kids. It's just kind of a generic text message that I've done this and I'm coming your direction. So I understand the concern. I understand Mr. Bierbauer's motion for contempt. I have to find willful and voluntary by a preponderance. And in this case, I'm not going to make a finding of contempt as to this accusation. However, since I do have Ms. Bierbauer here, I can't stress to you enough how important it is this man is not around your children, period. because it sounds like he's around them very regularly. If Mr. Bierbauer does file additional contempts and or there's proof that he's contacting one of the children through telephone or FaceTime, the court's not going to look very kindly on you based on that behavior. So that's something that you're going to need to make sure that you monitor and discuss with Mr. Williams as much as you can. Ms. Height, I did state I'd give you an opportunity to weigh in if you had anything you wanted to say. So if you do, by all means.
The only thing I have was that I did speak with Heather Trent, who had served the documents and saw Mr. Williams there, but you have already addressed that part of it. And so she was very specific and precise and I would say believable in what she said, but that is, you've already addressed that. So I feel like that's probably not something that needs to be rehashed.
Well, like I said, Mr. Bierbauer, the only contempt that was before me is the May 24th accusation. It's up to you if you want to file additional motions for contempt based on that other activity that is not before me today. And again, I'll just.
What about the one for 514 where Ashley didn't call me? If I remember right on that, when that Mr. Nelson signed that, he told her that he had to contact me, that she had to contact me.
Your Honor, I believe what he's referring to was just spoken in court. It's not on the order that he wrote. She was to contact him if Mr. Williams had not vacated the premises, and he had at that time. So she was to contact him if he was going to have to take the kids for the upcoming week because Ms. Bierbauer could not. That was not the case, and so there was no communication necessary. They made the exchange as usual.
If I remember, I actually remember Mr. Nelson stated that she needed to contact me to let me know that he did not or did vacate.
Regardless, that's not in the order.
Okay, it's not in the order, number one. Number two, I believe Mr. Bierbauer is actually correct on this, but as I stated, it's not in the order. So, or excuse me, I think Mr. Hawkins is correct. It says the notes say Mr. Williams to be out of the house before Sunday when children arrive home. If that is not possible, then mother must send a message to father so children can remain with father until Mr. Williams is gone from the home. So there wasn't she needs to contact no matter what. And additionally, in the bench order that I reviewed, that language isn't in there at all. So again, I'm not going to make a finding of contempt. That doesn't preclude you from filing on those three other issues that you raised today. And Ms. Bierbauer, I highly recommend you speak with your attorney because you are represented. So you don't need to speak with me directly unless Mr. Hawkins is okay with that. And clearly the court's order is that Mr. Williams not have anything to do with these two children. So that should be followed. All right.
Thank you, Your Honor.
All right. Thank you. All right, next I have Inri Bierbauer. This is cause number 23-30001-308.
Good morning, Your Honor. Michael Reed appearing for Ashley Bierbauer.
Thank you. All right, so I've got you there, Mr. Reed, and I've got Mr. Bierbauer, I've got Ms. Powers, I've got Ms. Height. And Mr. Reed, you're appearing for which party?
Ashley Bierbauer. Josh Hawkins is not available.
Wonderful. Thank you so much.
I think he may have withdrawn.
I appreciate you for being here. How about that? Okay, we're on for review. This was last on back in June. Looks like at the guardian ad litem recommendations that was father to be primary, mother to have essentially the weekends and children to attend school in Cathlamet was the recommendation. Back in May, looks like the court essentially set the parties to week on, week off for the summer and set today for the review to decide essentially the school schedule, where children are going to reside primarily and where they're going to go to school, and what contact the boyfriend should have with any. So that's what looks like we're on for today. I'll turn it first to Ms. Hyde.
Thank you, Your Honor. Did the court have an opportunity to I've filed 3 reports in this case. The most recent I filed was on the 11th of August. That was the final kind of response to what Commissioner Nelson had particularly wanted addressed at this
Yes.
hearing. Were you
I
able-
did. I reviewed the Guardian Ad litem report filed August 11th, 2020.
Correct. Okay. I think that pretty well states my concerns and my recommendations. There were some slight modifications from the previous one, but essentially it was the same as the original report.
Very good. Anything further you'd like to add?
Not at this time, thank you.
All right, very good. Mr. Reed.
Your Honor, what we were concerned with is the children's ability to perform well in school. They have historically been with their mother. We understand that the report indicates that they're doing well with their father, but mother is still concerned about how they'll be able to do. She notes that this is a significant change from what was going on before this case was brought up, and she is still just concerned about their welfare. She is more concerned about their welfare than she is about Mr. Williams, which I would understand would be the court's concern at this point. She understands that she needs to keep him separated from the kids, and hopes that someday that they will all be able to get in a better place.
Thank you. I
Thank you.
appreciate that. Mr. Bierbauer.
All right, can you hear me now? There we are.
Yes,
Good
thank
morning.
you. Good morning.
I got a lot of things, but I would like them to come live with me. I don't want them around Mr. Williams due to his criminal history background. And they love it down here because they're able to go outside and play with the neighbor kids. And I'm in the process of building a pallet fort for them. So I will have that done soon for them. As to the living situation, yes, I do live in a travel trailer, but they have a bedroom in my dad's house, which is 50 feet away, that has a twin bed, 2 twin beds in there for them. And they know it's in there, but they prefer to sleep in the trailer with me because they feel they're camping. So as the living situation, everybody lives in a travel trailer. There's a lot of people that live in a travel trailer with a family. I don't know why that's an issue. I am looking at eventually buying a bigger trailer or moving into a house. But right now, as financial situations, it don't quite work that way. So, and like I said, I have a lot of other stuff. So, but we can discuss that later on.
This is your opportunity to speak before I make a plan for what's going to happen essentially until you get to a final order. So this would be still be a temporary order, but it'll be what's in place for the foreseeable future.
Okay, like I said, if they do come to live with me, I'm going to need all their medical info. That's their social security cards, all their meds, their clothes, toys they want to bring, the tablets and all that stuff. And any residential changes between me and her need to be notified by certified mail. It's stated in the dissolution divorce paperwork that I filed on January 12th. That's what this started out as, was a dissolution of divorce case, and it moved to a custody case. And then, any child support changes and all the birth certificates, immunization records. And another deal involves child support. We lived together from 18 to 21, and Ashley still collected child support from me. And I asked her numerous times to stop that, but she chose not to. So there's 3 years of child support that was taken out of my paycheck as I lived with her at 1924 Dorothy.
Okay. Thank you, sir. I appreciate that. Ms. Powers, I see you look like you are present on this case as well.
I am. Thank you, Your Honor. I would just ask if the court changes custody today, that you set a date ending the father's child support obligation. He is paying through an administrative order. He is almost paid in full for the month of August, so I would suggest maybe ending the obligation August 31st.
Okay, thank you very much. I appreciate that. All right. Thank you, everyone. I appreciate everyone for being here. Again, it's the court's goal to make the best decision it can with the information it has at the moment. I recognize this is not trial. This is still, we're still on for, these are still temporary orders. These are not final orders. We do have graciously the report of Ms. Height, who talked to both parties, talked to witnesses, talked to the kids, made efforts to sort of find out the information that would help the court or assist the court in making the best decision it can, which I do appreciate having that. Again, it's clear both parties deeply love their children, want the best for their children, want children to be healthy and happy and doing well. And that's good. That bodes well for the children ultimately doing well in the long term. In this case, I am going to order that the children live full-time with Mr. Bierbauer and largely adopt the guardian ad litem report. Mother will have the children every first, third, and fifth weekend. That'll be from Friday at 6 to Sunday at 6. If I think that's appropriate. I'd like the parties to adopt essentially a standard holiday schedule. Mr. Reed, I think you would imagine, I'm sure that you understand what that means. Mr. Bierbauer, that just means a fairly even sharing of the holidays until we get to trial. In the summer months can be week on, week off once summer vacation begins, but there's to be no contact with Mr. Williams during those times. So both during mother's regular visitation as well as the summer months and vacations, extra holidays, there's not to be any contact with Mr. Williams. He needs to not reside where she's residing when the children are there. So that doesn't mean he's hidden away in a closet. It means he's not there at all. Children are grade school aged. They should have access to call mother as desired. They should also have whatever devices they have can connect and communicate with mother as desired. Children's messenger and those types of things. Different gaming systems have that ability. Children should have that ability to chat with mom as desired via those devices. There should be a minimum of one phone contact a week that's a set date and time. And Mr. Reed, I'll leave that up to you and Mr. Bierbauer to set up the best day and time for these kids so that there's a set one. I would encourage more contact, but I want a minimum of one call a week for the children to connect with mom. All of the children's medical info, who their current physicians are, all of that. Insurance cards need to go to father. That's appropriate. Children's toys and clothing. Children's toys belong to them. That needs to go to father. So whatever the children's sort of personal items, children this age, loveys, special blankets, stuffies, those types of things need to go with the children. Nobody's going to sort of withhold those from the kids. Those belong to the kids. They need to go with the kids. Mr.'s obligated to provide his own clothes for the children, so mom doesn't need to send like the kids' closet though. Both parties need to provide that on their own. Let's see. I think that takes care of, and Mr. You will have an obligation to let mom know about anything that the children are involved in, as well as school activities and those types of things. So if there's an open house, a soccer games, those types of things, you need to let the other parent know so they can attend. Mom's free to attend all of those special events, soccer games, whatever it is. Both parents can and should attend. I am going to end Mr.'s child support obligation effective August 31st of this year. So that obligation will end. I'm not addressing what child support will be going forward. Any party, including the state, is free to raise that. I'm just going to leave that to a separate motion hearing, though, because I don't have financial information to make really any decision on child support at this point. I believe that takes care of all the decisions. Anything from you, Mr. Bierbauer?
I have one. Can we change the pickup and drop off time from 6 o'clock to 5 o'clock? I work till about 4.
Okay.
And we've been doing 5 to 5.
Okay.
And another thing is I can pick them up on a Friday night at the Fred Meyer parking lot because that's where we meet. But is there a way that she can come pick them up instead of me having to drive back into town? I live out in Cathlamet. That's a 40-minute drive.
Yeah.
And
the parties need to share the transportation obligation. I don't have any issue with changing Mr. Reed it to 5 o'clock and 5 o'clock. It's the same amount of time. Mother should pick up in Cathlamet. Mr. should, and I'll leave it to the two of you to create a location that works for everyone. Father can pick up to pick up on his to start his time at the Longview Fred Meyer. And that's just off of Ocean Beach Highway. So that's reasonable. So I'll leave it to the parties to find a good transfer location in Cathlamet since that's pretty small.
Okay.
Any questions from you? Oh, go ahead, Mr. Beerbauer.
And I picked them up. Tomorrow is actually my scheduled day to pick them up, I believe.
My plan's going to go into effect right now. So what I'm going to do is I'm going to leave the children with mom until Sunday. And so then you'll pick up on Sunday at Fred Meyer. And then that'll start the regular visitation as I've outlined, mothers every first, third, and fifth weekend.
Okay.
Okay. And those are as defined by Fridays. So when you look at a calendar, I say look at the calendar with the boxes with the puppies and the kittens on the picture on the top and the boxes on the bottom. When you're looking at a calendar like that, you're going to look at the Fridays, and it's the Fridays that determine what's the first, third, and fifth weekend.
Okay.
Mr. Reed, questions from you?
No, Your Honor, I think you've covered everything.
All right, very good. I'm going to ask you to prepare the pleadings, Mr. Reed.
Okay.
Governor, Your Honor, if I might.
Yes, please.
I do have in my my final report from August 11th. I also recommended that medications be on site at both parents' homes rather than sending medications back and forth. It's been a problem in the past. And if that could be part of the order as well, I think it would be helpful for all the parties.
Tell me about what kind of medications. Are we talking about pills or like an injectable?
They're pills.
They're pills. I've got the list of them if you want them.
No.
But
It can be challenging. So what are you envisioning? Usually a pharmacy is not going to give like a duplicate order. And so
I understand that. And that's why I was wanting it to be addressed. In the past, there's been some problems if one of the parents mother ran out and there wasn't enough to go through the father's whole week. And there's just been some kind of glitches recently about that. And maybe that will be solved by the fact that there won't be so much off time, but it was concerning enough that I wanted it to be addressed in some way by the court.
Okay, thank you. I appreciate you bringing that to my attention. The children's medications are very important. If they're prescribed, they're prescribed. And that means that they need to happen. So children the order can include children to receive their prescriptions as directed by their physicians. Mr. is going to be primarily obligated to take care of the refills. So they're primarily with you. That's going to be your job, sir. So you'll need to take care of their refills. You're also going to be obligated to make sure that when you send children to mother for either a holiday or a weekend, that they have sufficient medication to make it through that visit, so that mom has enough medication to be able to complete the visit and give all the meds as prescribed. Does that make sense?
Yes, it does.
Okay, so I'm sort of making you the most responsible party as to that. And so really, if a failure happens, it's the court's going to be looking for you. Yes. All right. Very good. I'm glad we all understand. Thank you, Ms. Height, for bringing that to my attention. All right.
Thank you, Your Honor.
Anything further, Ms. Height?
I believe that covers it. Thank you.
All right, Mr. Reed, presentation. What would you request? Do you want 2 weeks?
Yes, at least 2 weeks. Thursdays are never good for me, so I'll take whatever we get.
Okay, I can give you either September 7th or September 14th. What's your preference?
We can go with the 7th.
All right, so I'm going to set the matter over to the 7th. Mr. Beerbauer, Mr. Reed is going to create documents and send them to you that reflect my ruling today. If you believe that anything that he writes in those documents just doesn't reflect my ruling, then I'd ask you reach out to Mr. Reed and let him know that, and then also file something with the court that lets me know specifically what you don't believe reflects what I ordered. If everything's agreed on the 14th, we'll go ahead and enter the documents at that time.
Was it 7th or the 14th?
7th?
Oh, I'm sorry, the 7th. We went over
What time?
at this same time at 9 a.m.
Okay.
So the 7th, just to be clear, at 9 a.m. All right. Thank you all for being here. I appreciate your time. That concludes this
And
matter. Oh, go ahead, Mr. Beerbauer.
I believe Mr. Hawkins has my email and phone number on file.
I have
So,
it, yes.
All right.
Perfect. All right. Very good. All right. Thank you all. Best of luck to you.
Thank you, Your Honor.
Thank you.
Your Honor.
Your Honor, Amy Powers here for the state of Washington. I'm here on Beerbauer and Beerbauer, which is number 4 on the docket. We're here for presentation, and I just got served with the proposed final parenting plan this morning, or saw it in my email this morning.
Right.
The hearing, I believe, had been in front of Commissioner Baldwin, so I don't know whether the parties are in agreement or not, or if this is going to need to go over.
Right, Your Honor, this is Michael Reed appearing for Ms. Beerbauer. It was my responsibility to get those done, and I apologize. I've been in trial for the last week, so I didn't get it done until this morning. If we can, I think we'd like to ask for that to be sent over.
Have you, Mr. Beerbauer, have you been able to see those proposed orders at this point? You're still muted, sir.
There we go. I received them at 8 o'clock this morning also.
Okay.
And so
have
I
you been
haven't
able-
had time to, nope.
Okay.
I've been trying to get my kids ready for school.
All right. Is 1 week enough time for everybody?
They've
That'll be
been
enough for me.
prepared. I assume that there won't be any issues.
All right. I'll set this over to the 13th at 9 a.m. Mr. Beerbauer, if everything in the proposed order looks like what the commissioner ordered and you're in agreement to it and you want to sign off on that, then we can strike that hearing next week. You don't have to come back and we can just get the orders entered. But if there's something that you have a question about, then it'll just be on the docket next week and you can ask those questions of the judicial officer on the docket.
All right. Sounds
Okay.
good. Thank you.
All right. Thank you.
Can I ask really quick, Your Honor, the order I was served with was a final parenting plan. Are the parties hoping to enter final orders next week? There wasn't child support with it.
I don't believe so. I think that may have been inadvertent. We'll take another look at that.
Okay,
Thank
thanks.
you.
All right. Thank you.
Jeffrey Beerbauer and Ashley Beerbauer. Okay, we are on for presentation of an order from a hearing on August 24th, and it looks like I don't have a proposed order.
Course for the state of Washington. Attorney Joshua Hawkins represents Ms. Beerbauer and did send out a proposed parenting plan. I don't know why it hasn't reached the court yet. And I don't know why Mr. Hawkins is not here today. Do you want to set it over 2 weeks or 1 week and I can email Mr. Hawkins?
That sounds like about our only option. You understand that, Mr. Beerbauer?
Can we do it 2 weeks?
Oh,
I have
okay.
no
Next week is
objection to
judicial
that.
conference, so it'll have to be 2 weeks. So it'll be the 28th at 9 o'clock.
All right. Thank you.
Thanks.
Beerbauer and Ashley Beerbauer.
Good morning, Your Honor. Michael Reed appearing for Ashley Beerbauer.
Amy Powers for the state of Washington.
And Ann Height, guardian ad litem, Your Honor.
And do we have Mr. Beerbauer?
Good morning, Your Honor.
All right. I have a proposed parenting plan order. Mr. Beerbauer, you seen that?
Yes, I have. I got it at 10:30 and I wasn't able to review it till I got home last night after work and
Okay,
after I took care of my kids.
so does it look like it accurately reflects what the ruling was?
There's a few things that I would like changed.
Okay, that's not my question. So listen carefully to my question. Does the order accurately reflect what the court ruled?
Yes.
Okay. And Ms. Height, from your standpoint, is that
Yeah.
true?
Yes, Your Honor.
Okay, so Mr. Bierbauer, if there's some things you want changed, you need to bring a motion. The issue today
Okay.
is just presentation. Is this order reflective of what was decided?
I've also reviewed it, and there is a sentence in there about child support, which is appropriate.
All right, thank you, ma'am.
Which I bring that was actually taken out of my check again.
I will contact the support enforcement officer again. I gave them notice, but now they've been waiting for the signed order. I'll make sure they get a copy of that.
Thank you, Ms. Powers.
Yeah.
All right, thank you all.
Thank you, Your Honor.
Thank you. Bierbauer and Bierbauer, 233-000-1308.
Afternoon, Your Honor.
Good afternoon. Thank you both for your patience here. It's been a long afternoon. Okay, we have a few different things. It looks like there's a request to transfer to mandatory mediation. There's a contempt and a request for some temporary orders. And I believe that Mr. Bierbauer, you're the moving party in these. So I have reviewed everything that's been filed. I do have all your proposed orders in front of me. So if there's anything that you at this point would like to state, I am all ears.
If Ashley wants to go first, that's fine. If she wants to try to talk about this, and that would
Miss,
pretty much,
so you just want to stand
Yeah.
on your documents?
yeah.
All right. Ms. Bierbauer, any response to those requests?
Yes, I turned in declarations yesterday. I was served with these papers last week for this court hearing because I don't have a lawyer, and I think he served my lawyers instead of me. So
I did note, and because you're here, I kind of ignored it, and I apologize for interrupting you, but I did note that it looked like your attorney was served and right around the same time that they withdrew. You're here. I don't know when you got notice of this. I will tell you that I do see that your declaration made it in. I don't know, but I do want to inquire whether you feel you had ample time to respond because of the notice.
well, I wasn't able to get like my medical records to send to you to show that I do not have any drug or alcohol abuse in my history. I'm not on drugs. So that is a complete unbiased and slanderous comment. So I can get my records, but that takes time. And so I have been in contact with my doctor yesterday, but it of course goes through records and you have to take the time to get it from them.
Okay. What I'm going to start with, the first thing I'm going to start with is there's a motion to transfer this case to mediation. Is that something that you're at all interested in? Because frankly, if you're willing to mediate, then I may not want to make a decision on any of these things and allow you to work with an independent third party to try to mediate this situation. If that's not something you're interested, then we'll move forward and deal with all these issues.
Your Honor,
Yes.
I'd like this done and over with. I don't want my last name associated with her current boyfriend and his past and her. I want it done and over with.
Well, you're the one who filed the motion to transfer to mediation.
I was following what I was told to do was that I had to file the mandatory mediation paperwork to start the process because of the time restraints, or it's coming up on almost a year of court. And I've missed a lot of work for these court dates.
Okay. Well, it's a dissolution with children involved. So there are certain steps that are required statutorily to take place. Mediation, it's either mediation or a mandatory settlement conference. One of those two are required before you can get a trial setting.
Okay.
So, and I know that the temporary parenting plan was only entered a couple months ago.
Yes.
One of the allegations is that since that's been entered, Ms. Bierbauer hasn't been taking part in those visitations.
No,
which
she has
is-
not.
which is the basis for the contempt that was filed. So, in either a mandatory settlement conference, or if you go to the private mediation, that's available through, it's essentially a referral from us to, mediation, you're able to essentially finalize this case if you come to an agreement. So I don't know, if you go to mediation, that's not scheduled through us. So that's independently, you're calling the mediation center, you're getting an appointment with them as quickly as you can, which in some cases they've been able to meet within days of calling. And they work with you, work through the process, and if they're able to resolve it, then they get finalized orders back to the court and it's done. If you do a mandatory settlement conference, that's a judicial officer, either a commissioner or a judge, that hears your case and tries to resolve the case. You can also do a binding settlement conference. This may be too much information, but that's basically where you go to a mediation type setting with a judicial officer, and ultimately the judge makes a decision. So it's kind of a informal trial process that you try to mediate your way through and find agreements between the parties. So if both of you are saying, let's try to get this set up for mediation right away, then I'm not gonna address all these issues. I'm gonna see if you guys can find a medium ground to work on, and maybe even resolve your dissolution and the parenting plan all in one blow. If you don't want to do that, then we'll deal with all this filings today. So
I want to deal with all the filings and do it the other way, whatever the settlement or whatever it is.
you want to do the settlement way?
Yeah. Because I want to get the other two deals that I filed taken care of today. It's tearing my boys apart.
Okay, so you want to do the contempt and then the other things go the other way?
Yes, Your Honor.
Do you have a response to the contempt? The contempt is that you're not sorry, I gotta pull up the right document here. That you've not picked them up for their scheduled visits on several weeks since that parenting plan, the temporary parenting plan, was entered back in September. Any response to that?
Yes, I've put my declaration in. It's in my declaration. So I was involved in a rollover car wreck at the end of August. That kind of messed up September for my visitations. My mom was here for the first visitation because I was on pain meds for my back and I had a severe concussion. As far as the rest, I no longer have a vehicle. I was using my mom's. She moved to Montana in September. So without a vehicle that is running, I have not been able to go get the kids. I've told him, I've asked him to bring them to me. He will not. He says that is not in the paperwork, and that unless I come get them with a vehicle, that I cannot take the boys for my weekends. I have told him that, and he has continued to take my boys to the pickup point, which is detrimental to them. This is not okay. And he has pretty much makes them feel like I have forgot about them. Even when I gave him a heads up, I still don't have a vehicle. I have told him every time ahead of time, there's no reason he should show up and try to make me seem like a monster to my children. I call them every Wednesday. In September, I did miss some because I was recovering. Other than that, I call them every Wednesday. Even when Mason's too tired and goes to bed, I still talk to Hunter. We have a great conversation. And I'm always telling them how proud I am of them and what they're doing. And I ask what they're doing. I'm not being told about Christmas recitals or anything. So my kids are like, well, you didn't go, Mom. Yeah, I didn't know. And I was hoping there was another one and there wasn't. So I'm also not being incorporated into their lives to be there for them. I have finally made it to where I'm going to have rides for them, but I haven't been able to, just because with my mom leaving, I really don't have many people here to make sure I can get rides to there. I don't have a lot of friends or anything like that. I don't have family that I am with, like I can ask for those things. So, like right now, I have a ride for Christmas to go pick my boys up whenever he decides I'm able to do that. And then he can pick them up at Fred Meyer's so I can have at least a few hours on Christmas Eve. But he wouldn't even give me a few hours on Hunter's birthday to bring them to me so I can spend time at Dairy Queen. I have been just kind of pushed away as far as being able to see them because I don't have a vehicle. So I've been trying to just be able to find people, and I've finally been able to find a couple people that I feel secure with to drive down there to pick them up and actually get my time with them. But I'm always calling them on my Wednesday times to talk to them. I have not forgotten about them or made it seem like they're not a priority to me. They are. Again, I still don't have a vehicle, and that is something I'm still trying to reconcile to get done. But I definitely don't want my children taken away completely.
All right, I thank you, Ms. Beerbauer. Ms. Height you're here. I know that you were involved before the temporary plan was put in place. Is there any input that you have or would like to relay to the court?
I have no real fresh information. I've had a few updates on how the kids are doing. It sounds like they're doing great at school, and that has all been positive. The other update is that I heard about a week ago that Mr. Beerbauer and the boys will be moving into, I believe it's a 3-bedroom home right after the first of the year. So their housing is going to be more advanced than what they're undergoing now. But other than that, as related to this particular issue, I don't have any fresh input.
Thank you, Ms. Height. I appreciate that. All right, in order to make a finding of contempt, the court has to find that there's a clear and willful and intentional violation of a direct court order.
Your Honor, can I say something?
Sure.
On 12/13 of this month, Ashley told the boys that she was doing the Walmart deliveries again. And that's when she stated that she could not pick them up because she didn't have a vehicle. And to my understanding, in order to do the Walmart deliveries, you have to have a vehicle. And another thing is, she states she doesn't have the vehicle. I'm going to be honest with you. Both her and Derek were spotted today about 10 o'clock this morning at the 38th Avenue Walmart in a black Honda Civic. I saw them. My girlfriend was with me and my dad was with me. We were coming to Walmart. She has a vehicle and has had a vehicle all of these days that are stated. It is her choice to state that she does not have a vehicle. That is her excuse every time. And her calls on Wednesday nights, they last no longer than 15 minutes. And it states that the boys, where Mason did not want to talk to her, he didn't. He was not asleep. He did not want to talk to her because he had nothing to say to her. Hunter, same way. They do not ask me how mom is doing or to call them, to call her. So this is what it is the fact that they're not getting time with their mother is tearing me apart and them apart. That's why I'm doing it. It's her choice right now. It's not mine, and it is not my responsibility to drive my boys into Longview. It is her. It states in the parenting plan on, 12 on that she is the picking up parent. That makes it her responsibility to come down to Cathlamet. I cannot afford to drive into Longview twice a weekend. I drive a diesel pickup. Diesel is almost $5 a gallon. And I work, so on a Friday night, I would have to get off work at 2:30, 3 o'clock, drive all the way down to Cathlamet, pick my boys up, turn around when they don't get home till 4 o'clock because they ride the school bus, pick them up and turn and beat back into Longview by 5 o'clock. That's making 6 trips in one day to Longview. I can't afford that, Your Honor. I'm
I'm taking care of my boys. My boys are my number one priority right now.
All right. Thank you, Mr. Beerbauer. I appreciate
You're
that.
welcome.
Mrs. Beerbauer, go ahead. And just make sure to unmute yourself.
The vehicle that I'm driving, I'm actually having to borrow so that I can work. I have not been able to work this whole time. I finally found someone who's allowing me to borrow a vehicle for work. I'm not able to borrow it to drive a half hour away. It's not my vehicle. So yes, I was in a vehicle today, but I'm not in that vehicle to go to Kathleen. That's not what it's for. I'm having to pay to rent to use this vehicle to try to make money to get a vehicle.
Okay. Thank you. This is clearly a difficult situation. I think finances and the distance is obviously a concern, frankly, for both parties. I completely and totally sympathize with father's frustrations, and frankly, the fallout from these visitations not occurring, he's bearing the brunt of that. I completely understand that, and I appreciate that very much. And I'm sure it's been unpleasant. And my hope is that there will be an ability of mom to follow the parenting plan, make these visitations. But frankly, there's nothing in, and I'm sure Mr. Beerbauer disagrees, but I don't see anything that mom is intentionally and willfully violating the court order by not visiting these children. I'm talking now. There's visitation issue, or excuse me, there's the car issue. I know there's a disagreement about whether she has a car. If she's making the phone calls, and it does appear that most of the phone calls have been made. There were some missed phone calls listed in the allegation, and those were from, I think, the September timeframe. It's been a long time since she's actually seen the kids. My concern is, and this is directed to Miss Beerbauer, the longer you go without seeing them, the harder it's going to be for them to maybe want to see you. And I don't, and that's going to be an added issue for both you and their father. So my hope is that this can be resolved. I'm not going to make a finding of a willful violation. And so I'm going to deny the request for the contempt. I will authorize the mediation request. What I'm going to order the parties to do is reach out to, and Ms. Height can provide some information or assistance in this, but reach out to the mediation clinic. My understanding is that turnaround time on that can be very quick. So that's something that you could get scheduled potentially for next week or the week after. They're more than willing to work around work schedules and accommodate that thing. So I know that Mr. Beerbauer, that's a concern for you.
Your Honor.
But it sounds to me, my understanding is they could probably get you in relatively quick and start working on a resolution. If you aren't able to come to a resolution, then unfortunately you're back here. So Mr. Beerbauer, go ahead.
I can't remember what date it was, but she did state to the boys that she has no home. She was couch surfing with people, and that she had lost her home, her job, and her mom, because her mom moved to Montana, which I understand. So there's that. And I'm also going to bring something up here. It was about 2 weeks ago. I was assaulted by her boyfriend in the Walmart parking lot. She showed up unannounced in front of my vehicle at the 38th Avenue Walmart parking lot. And I politely said, "It is not your weekend. You did not contact me. You need to leave." And then her boyfriend, Derek Williams, decided to get very aggressive with me and come at me. And I was like, I'm not going to deal with you. I don't want to deal with this. I had my boys get back in the truck. I was standing on the step of my truck, and he come up and he assaulted me by slamming the door of my pickup into me in front of my children. And not once did she say not to do it to him because the boys were there. She looked at him and said, no, do not do this because you do not need to go back to jail. She never once mentioned the boys. And my girlfriend was standing right there and witnessed it all happen. And that is referenced in another deal of the case number.
Is there a criminal?
I do not want my
pending?
children around him.
Well,
What was that?
I asked if there was a criminal charge or if the law enforcement was contacted.
Yes, I pressed charges against him and I got a case number and I think it's listed in the other document.
Okay. I will remind the parties, especially Ms. Bierbauer, the children, are not to have any contact with Derek Williams. He's not to be present at any visitation that you have, any interactions that you have. He's not to be around the children, period. And that's part of the parenting plan that was entered back in September. So even if you showed up for a scheduled visitation and Mr. Williams was there, it would be, frankly, probably Mr. Bierbauer would be able to deny that visitation because Mr. Williams was there with you. I don't know why that was entered. I don't recall the history. I was not the judicial officer that entered that that parenting plan, but clearly there's a reason for that. So that's already a part of the record at this point and part of the order that's in place. So Mr. Williams is not to be around those children, period. Okay. And it sounds like Ms. Height, I swear I saw her nodding her head that she would be willing to help get you in contact with the mediation, point you in the right direction there. And like I said, they're happy to accommodate work schedules and try to set up something. I know sometimes they even do what we call after hours mediation if that's what's necessary. So I will happily.
They're very accommodating, Your Honor, and I would also pleasantly let both parties know they have a sliding fee schedule and are very accommodating as far as fees go as well. So I think that could probably be a really good way to get to a resolution on this case.
So please reach out to Ms. Height if you have any questions about that. There's the clerk's office also has information about how to contact them. I'm going to sign the order transferring the case to mandatory mediation, and I really wish you both the best of luck.
Thank you, Your Honor.
Thank you.
Next, I have Jeffrey Bierbauer and Ashley Bierbauer, cause number 23-13-08. I'll ask if Jeffrey Bierbauer is present.
I'm present here, Your Honor.
Okay, welcome to you, sir. And then I'll ask if Ashley Bierbauer is present.
Yes, I am, Your Honor.
Welcome to you, ma'am. I also note that guardian ad litem Height is here. Ms. Height, can you hear me okay?
Yes, good morning, Your Honor.
Good morning. It's still morning, just barely. All right. So we're here today on Mr. Bierbauer's motion for contempt. And it looks like Mr. Bierbauer served a copy of his motion and the order to show cause on Ms. Bierbauer on June 27th. The concern with that is that it's a shorter period of time than the rule calls for. And so my concern is that we know what Mr. Bierbauer's alleging occurred via the contempt. However, there's been not enough time, according to local rule 88, for Ms. Bierbauer to supply a response. So my initial reaction to the motion is that there hasn't been the sufficient time between the time of service of the documents on Ms. Bierbauer and today's hearing to allow her adequate time under the rule to respond. So I'll hear from the parties if you have any comment on that, Mr. Bierbauer.
I do. I tried for a week to have her served. And my people that served knocked on the door every day for a week, and they could hear her in the house. She would not answer the door. So
I don't understand how this is not enough time when I served her on the 27th and it's now the 10th of July. That's more than the 7 days that's allotted.
When you say the 7 days, when you're referring to that, where's that information coming
That's
from?
what I was told, that I have to do it within 7 days or
Okay.
whatever. But this is the third time I've been at contempt and nothing's been done. I need something done because it's not healthy for my boys to be where they're at right now and who she has around.
Okay. So I'm making reference to local rule 88, and it indicates here the following. It says all domestic relations motions shall be filed and served upon all parties not later than 21 days before the time specified for the hearing.
Okay, I was never informed of that rule
Sure.
by
Sure.
the court system.
Yeah, it's not uncommon that people aren't aware of all the different rules that apply to a particular hearing. And I recognize that providing service in a timely fashion can sometimes be really tough, and sometimes doesn't happen super fast, and it takes multiple attempts, and sometimes people try to avoid service too. So with the service on the 27th to today being the 10th, I think that's a total of like 14 days roughly. So we're a little bit shy of that 21 days. So what I'm proposing is to set the matter over 2 weeks to the 24th. That would be beyond the time required by a little bit, and that would allow Ms. Bierbauer to supply a response to the court and also serve a copy to Mr. Bierbauer, and then the issue can be addressed and decided by the court. Any questions on that approach if we were to come back on the 24th?
The only issue I have with that is I can't be missing work. I mean, I missed work today. I'm the sole driver at my company, and I had to pull tooth and nails to get covered. So I'm having a hard time missing work because I'm also losing out on money to support my children.
Right, it's kind of a catch-22 in a rock and a hard place. I recognize that. So then would the 24th work for you or not?
It'll work. I just have to see if I can get somebody to cover me.
Okay, all right. Ms. Bierbauer, as far as your response, you'll have opportunity to file a response to the motion that's been filed by Mr. Bierbauer. You'll need to file a copy with the court and also send a copy to Ms. Height and send a copy to Mr. Bierbauer. And then we'll be here on the 24th to hear your respective positions, and then I'll make a decision on that motion for contempt. Do you have any questions?
No, Your Honor.
Ms. Height, do you have any questions or comment?
My only comment, Your Honor, would be to ask the court to remind Ms. Bierbauer that per the last hearing, the guardian ad litem recommendations were adopted that prohibited Mr. Williams from having any contact with the children. And I would like to make sure that she is aware of that going forward, just as a safety consideration for the boys.
Your Honor,
Thank you, Ms. Height. Ms. Bierbauer?
I want it known by everyone in the courtroom that my sons have not had a conversation nor have been in the same room with Derek Williams since I think the court decided back in April he had to move out of the house in 2023. So I am aware, and I am not having him around my children.
Okay. All right, yeah. So Ms. Height just rehearsed what was contained in the September 28, 2023 order under section 14.2, which states the children are to have no contact with Derek Williams or be present at the mother's residence during any of the mother's on-duty parenting time. So that's a valid court order, and Ms. Height was just drawing all the parties' attention to that. So we will be here on the 24th of July. We'll look forward to hearing from both parties at that time. We'll see everybody then. Thank you.
Thank you,
Your Honor.
Why did you not ask to talk again?
I tried to, and he ended.
Next, we have
Beerbauer 23-3 13-08. Morning.
Good morning, Your Honor.
It looks like, sir, you filed a declaration today.
That is in response to her response that I emailed to at 6 o'clock last night after the court was closed.
Okay. So I assume you have not seen this yet, ma'am? You're muted. So two things, neither of those responses would be timely for today.
We were set over to today for the 10th because I filed the paperwork and had her served on the 27th of July or of June. Because she hadn't done a response until last night.
I don't see, none of those were filed with the court. But I did see a bench copy that came in yesterday. I believe it was when I saw it. So at this juncture, I mean, there's two things. I know she filed something which came in, I assume it was yesterday, or that's when I looked at it last night before today's hearing, and my notes indicated that you said she did it. She said she didn't, so I was going to deny it. You've now filed some additional, which it sounds like she's not seen. So I mean, I can set it over and have her look at that, and then we can have another hearing. But I mean, I don't have a basis to do anything today.
I understand that this is the third time that I've taken her to contempt, and I'm jeopardizing my job right now by missing days of work.
I understand that. I just, I set this out a week or two. You can appear via Zoom if you'd like, and that's perfectly okay.
Either or is fine. The 31st was work because we also have work that day also.
Okay, well, let's put it on for the 31st. That your documents are here, that you filed these with the clerk?
Yes, I filed them this morning.
Okay, and you sent a copy to her?
Not yet, no.
Okay, so she needs a copy of this as well, and you can do that. You were served via email, you said?
I was served via email that were photos of her response from.
Okay, so ma'am, I'm gonna have him email you what he just brought in today. I'm gonna put this over 1 week to next Wednesday, the 31st at 9 o'clock, and then we'll address the issue of contempt. Okay?
Okay, thank you, Your Honor.
Okay. And we'll go ahead and hang on to these, so these could get to Judge Evans, and he'll be here next Wednesday at 9.
That's fine.
Okay, and again, if you want to appear via Zoom, you're welcome to, if that's helpful. Okay. So in the Beerbauer and Beerbauer matter, which is 23-313-08. I think I saw Mr. Beerbauer is present. Is Ashley Beerbauer present? I see her there. If you could unmute, please, ma'am.
Morning, Your Honor.
Good morning.
Good morning, Your Honor.
Good morning. And it looks like, is Miss Height present?
I am, Your Honor. Good morning.
Good morning. And it looks like the state of Washington may be involved, but that's probably not anything that we're talking about today. So when I looked at the issue that was before the court that I can see, there's a couple. One is just a pretrial to make sure we're still all ready for trial, which is coming up, I believe, fairly quickly here.
We also have the contempt that was from last week.
Correct. So I'm just looking to see. So you have a readiness hearing on August 13th, which is a Zoom hearing like this. It's at 11:30. And that's when you'll get an actual trial date for that following week. Excuse me, which is the week of August 19th. So you're both ready to go at that, forward on that?
Yes, Your Honor, I am.
And you, ma'am?
Yes, Your Honor.
Okay. So that's just me confirming we're not missing anything. So on the contempt issue, this has to do with essentially visiting unsupervised. And I believe that was with some specific requests for, so my question, and I don't know that I've got an answer here. Just a minute here. We got something that was filed late. So this is the issue about Mr. Williams being present around the boys.
Yes, Your Honor.
And ma'am, you filed a declaration, said that that hasn't happened. Is that right?
Correct. He has not been near the boys. There is no proof of this because it has never happened.
Your Honor, can I state something?
In just a minute, sir.
Okay.
Okay, just one at a time. Let me ask you some questions. I did review all of your information. So it looks like Mr. Williams is the one who accepted the paperwork in this case. So are the two of you residing together?
We are no longer living together.
And when did that take place?
A month ago.
A month ago. So he was there on the 27th of June, because that's who got the documents in this case. So that was about a month ago. So he got served papers, then he moved out?
Yes, he did. And he changed his registered address.
I'm sorry?
He registered his address and it was changed there's proof of that.
Where was that done?
The sheriff's department.
Okay. Ms. Height, do you have anything you can shed any light on this for me?
Your Honor, I have not had recent contact with the parties after I filed a couple of reports. I have received the same documents you've received, and they showed some pictures of Mr. Williams at the home on July 7th and July 5th. Picture, I did recognize the entry of the home because it's where I had visited there. But beyond that, I don't know. I did speak by phone with Mr. Bierbauer about how the boys were doing within the last month or so, maybe last 3 weeks, and it sounds like they're doing well.
Okay.
Your Honor, I have not received any pictures for this case.
Your Honor,
Yes, sir.
on the 24th, I went down to the sheriff's office and paid the $40 to have her served with this declaration. They have attempted numerous times. She has not answered the door.
I have not had a card or anything in my door to say that.
Okay, well, there are some, these were filed on the 24th, it looks like. Would be about last Wednesday.
Yes.
And you say you haven't been served those papers?
No, I have not.
Okay. They purport to show, and Ms. Heights indicated that they do show Mr. Williams at your residence. July 5th. And I don't know where these come from, but so that's concerning, obviously. There is a restriction on that.
If he was there, it would be outside, maybe to exchange a vehicle. But he has not had any contact with the children or been in the house.
Okay, when is this is set for trial? In 2 weeks, 3 weeks? All right. Well, I'm concerned that she doesn't have that document to look at because that is fairly critical evidence.
I understand that, Your
Yeah,
Honor.
well,
Like I said,
just one second, sir.
okay.
Okay, go ahead, sir. I'm sorry.
I went down on the 24th after I was done and I have the receipt from the Cowlitz County Sheriff's Office and I have proof that the officer was at the door and she did not answer the door when he knocked.
Okay.
And I have contacted the sheriff's office also, and they have stated that no answer.
Well, the fact that somebody doesn't answer the door doesn't tell me anything other than maybe they weren't home at that point in time. So that's all that tells me at this juncture. I have some concerns about this case, obviously, because my concern really is that it appears that he's still around. He's the one who actually accepted papers about a month ago. And I guess my concern on that is that there's been an order that he's not supposed to be around the kids for some period of time. He was apparently there in the residence to accept papers about a month ago.
That was when I did not have the children, Your Honor.
No, I understand that, ma'am. What the concern that raises is you've got somebody that's not supposed to be around your kids, but he's still hanging around. And that puts a potential exposure of the kids to him. And I don't have the whole history of your case. If I hear your case in 3 weeks, I will have more information. Let me ask Ms. Height, do you have any concerns about the situation as it sits right now?
My concern, Your Honor, is secondhand information is what I have.
Mm-hmm.
There are pictures, obviously, that you've seen of the kids coming in and out at unusual times for kids of that age, around midnight and 1 a.m. I find that concerning. I also find it concerning that when they return to dad, it takes a while to get them tuned back up to be the way he wants them to be as far as rest and behavior. So I think that the visits are difficult for them. I don't know if they're dangerous. I do believe that Mr. Williams is highly inappropriate to be around the children. It does concern me that Ms. Bierbauer does not seem concerned about that, except, of course, to follow the rules that are in place. But actually having him around does not seem to be concerning for her, and I find that troubling. But again, that's all. I have not interviewed him lately.
Okay. Thank you. I appreciate that. Well, here's what I'm going to do. So, ma'am, I'm going to, since we apparently can't get these to you directly, I'm going to have you come to the clerk's office and get a copy of this document. Alternatively, Mr. Bierbauer, do you have a way to email this document to her?
I do, but I would prefer to do it all through the sheriff's office and have her served by them.
Well, and you have her email though.
Yes, I do.
Okay. So here's what I'm going to have you do. I'm going to have you email a copy of this to her with a copy to Ms. Height and a copy back to yourself. So you've got evidence that it was sent to her.
Okay.
I'm going to set this over 1 week. When do the kids visit next?
They are with me right now, and they will be with Ashley next week on Friday. Friday at 5 o'clock is a drop off time. Or pickup time for Ashley. We're on the summer schedule right now, so it's week on, week off.
Okay.
Which will be ending soon because they start school on the 27th of August.
Okay. So what I'm going to do is that I'm really concerned about this because it seems like this is not something that is kind of rising up to the level of concern, which the guardian is concerned about Mr. Williams. The fact he's still around, and accepting service at your residence a month ago, and this case has been going on longer than a month, obviously. That's concerning. So I'm not going to make a change to the parenting plan at this point. I'm not going to make a contempt finding, but I am going to set this over 1 week for review. Mr. Williams needs to not be anywhere near your property when those kids are there. And I think you need to take a long, hard look at that relationship as to whether or not that's something that you intend to keep going forward, because that very likely is going to have an impact on what we do in the case when we come to trial.
Yes, Your Honor.
So I am going to defer over to Judge Evans 1 week on the contempt issue. I want to make sure she's got those documents, because those are very, very concerning to the court. But you will have, if I see that, and if you can forward or send a printed copy of that down to the clerk's office for filing, so of the email you send, so we have that in the court file that was sent.
Okay, do I turn that in person, or can I just email it to them?
You'll need to drop it by,
Okay,
because they don't have electronic filing at this point. So drop that by, and then we're going to come back next Wednesday, and I'll pass my concerns on to Judge Evans, and we'll back at 9 o'clock on the 7th.
will I have to have Ashley served with proof that I emailed it to her, or just to the court?
You just email it to her with a copy emailed to Ms. Height
Okay,
and a copy back to yourself. So we've got proof that it was sent and you received it back, so we know it went out into the email system.
okay,
And then if you don't see that, you need to come down to the clerk's office to get a copy of this thing. So we're going to proceed forward with the assumption you've had that.
Yes, Your Honor.
Okay. So come back next Wednesday and address it.
Ashley Bierbauer, 233-1308 is the cause number.
morning, Your Honor.
All right. Good morning. That's Jeff Bierbauer. You can hear me okay?
Yeah.
Very
Can you hear
good. Ms. Height, yes, I can hear you, sir. Ms. Height is here. I can see her. She's the guardian ad litem that's been appointed and working on the case. And then I'll ask if Ashley Bierbauer is present. All right, Ms. Bierbauer, if you're on the line, please make sure you're unmuted and state your name. All right, and just confirming, Ms. Bierbauer, you're not in the courtroom? All right, looks like she's not in the courtroom. There's just a few people moving in the courtroom, so I wasn't quite sure if she was coming forward. And
He was on earlier.
And as Ms. Height, have you received any communication from Ms. Bierbauer as far as her presence today?
I have not, Your Honor, but I did see her name listed on the list a couple of hours ago.
Okay, all right. Let me ask Mr. Bierbauer, at the last hearing, it looks like Judge Brasher asked you to make sure that you emailed all the pleadings to Ms. Bierbauer. Did that happen?
Yes, it did. It happened on the, what was it, the 31st at 12:36 p.m.
31st, okay.
Yeah.
All right, well, I guess, I don't know, my sense, did anybody note when Ms. Bierbauer maybe went off the call?
I did not.
I did not.
Okay, yeah, it doesn't give you notice when somebody's leaving. You get to see them when they pop in. Maybe we could do this. I don't want to delay things too much with you all here. Maybe I could take one other case, address that, and then come back to your case so we don't unduly delay things.
That's fine, Your Honor.
Okay.
Your Honor.
Yes, Ms. Height?
I'll try to, while you're doing that, I'll try to make a call and see if I can find her.
Okay, that'd be appreciated. Great, thank you. All right, so I'll call one more case and we'll come back to the Bierbauer matter. We'll go back to the Bierbauer matter. Jeffrey Bierbauer and Ashley Bierbauer, 233-1308. Just confirming, Mr. Bierbauer, you're still on the line?
Yes, I am, Your Honor.
All right, Ms. Height is present, and Ashley Bierbauer, are you on the line? I heard a partial word. It sounded like a starting of the word yes. So Ms. Bierbauer.
Yes, Your Honor, this is Ashley Bierbauer.
Okay, great. All right, we're here on Mr. Bierbauer's motion for contempt. Ms. Bierbauer, earlier I called the case just a few minutes ago, and the indication from Mr. Bierbauer and Ms. Height was that you were here earlier, but they didn't see you on the call, so we decided we'd handle another case and then come back to you. I'll come back to this matter. I asked Mr. Bierbauer about last week when, or at the last hearing, Judge Basher required Mr. Bierbauer to email all the pleadings that have been filed to you. Did you get, and he indicated that he did, and I think he gave a specific date and he said it happened at 12:36 p.m. Did you get a copy of those pleadings?
Yeah, Your Honor.
So, Ms. Bierbauer, I apologize. Your audio quality is pretty poor. It came through garbled and I wasn't able to identify what you said.
I did receive that, Your Honor.
All right, very good. I appreciate that. All right, so we're here on Mr. Bierbauer's motion for contempt. And the indication is it's surrounding issues related to Mr. Williams. And in relationship to the September 28, 2023 parenting plan order, paragraph 14.2, which indicates the children are to have no contact with Derek Williams or be present at the mother's residence during any of the mother's on-duty parenting time. So that's the concerns raised. And as far as your response, I read your response, Ms. Bierbauer, and so I'm familiar with the pleadings, and I'll hear argument from the parties. So Mr. Bierbauer, if you want to go first, and then we'll hear from Ms. Bierbauer and Ms. Height. If you have any comments, I'd hear from you also, please.
So my regard is Mr. Williams. I don't want him around my children because of his background. And, you know, she states that he hasn't been there. Well, he's been spotted there. He accepted the papers on June 27th. And then the
Can I
weekend
ask you a question about that, Mr. Bierbauer?
Yes.
As far as the acceptance of papers on June 27th, you indicated he was at the residence where Ms. Bierbauer lives. Were the children present at that time?
No, they were not.
Okay, go ahead.
And then on July 4th, which was her scheduled week of visitation, and I've included it in my declaration, there's a picture of him on July 5th at the residence. And the boys were there because that is the night that she picked them up.
So you said that was captured in an image or a picture?
Yes, and that's with my declaration, Your Honor.
Let me, if you could kind of point me to that. Is this on?
It'd be page number 5.
Okay, let me pull that up here. Okay, so I see a photo. It's down to the left. There's a caption, Derek entering apartment 7/5/2024.
Yep.
Okay, so what's the time of that?
That it was, I think, probably around 10 or 11 at night.
Okay, so it's in the evening, 10 or 11. And then were your children at Ms. Bierbauer's home on the evening of July 5th?
Yes, they were, Your Honor. She picked them up at 5 o'clock on July 5th here in Kathleen at Dollar General.
Okay, so that was her residential time. She picked them up at 5 and then that was
Yes.
her time. Okay. All right, go ahead, please.
And then also on the, which would be page 6, is him coming in at 12:20, which I believe was the 6th through the 7th. So it would have been the Saturday or a Sunday night.
12:20. And these images, this comes from some type of Vivint product, and that's a neighbor, I'm assuming.
Yes, it is the neighbor of Ashley who fears for the safety of my children. I did not ask for these. She sent them to me
Okay.
because she's been having problems with him and Ashley, hence the security cameras. And she, like I said, she fears for the safety of my boys, so she sends them to me.
So you're representing that was on July 6th and at 12:20 in the morning. When did Ms. Bierbauer's residential time end on that weekend?
It didn't end on the weekend because she has them. We're on the summer schedule, so it's week on, week off. So it'd have been the Friday after. I don't know the date offhand.
Okay, so from the 5th until the 12th, they were with Ms. Bierbauer.
Yes, Your Honor.
Okay, go ahead. Thank you for answering my questions.
You're welcome. And then The other ones that's concerning is she's in the boys in at 1:15 in the morning, 11:15 at night, 12 a.m. during that week. That my boys need to be on their schedule for school because they start here on the 27th. And I've asked her numerous times to keep them on that schedule so they can get used to going back into the school schedule. And I don't know if she is doing that right now. But like I said, this was from back in July, the beginning of July. They need to be on that schedule, and I don't want them. I deal when they come back from their mothers. It takes me at least 4 days to get them back into a schedule because they don't listen to me. They don't want to do anything. They're tired. So I don't know. It's hard for me because I work, and so I've got to find a babysitter, and half the time they don't want to cooperate with the babysitter. And so I'm getting calls and texts from the babysitter that, hey, they're not listening. And I can't just leave my job that I do to come take care of my kids as I'm the sole driver for this company that I work for. I mean, I've missed so many days of work here in the last month and a half that I'm at the risk of losing my job. And so I want the visitation and everything revoked. And I want her to do a hair follicle test, drug test, mental health evaluation until she can prove that she's stable to take care of the kids.
So your request for mental health evaluation and hair follicle test, where do those concerns come from? What would be the basis of the court ordering those?
Because of Derek's background, and also that is a known drug house now. And
Meaning Ms. Bierbauer's house?
yes.
Okay. All right. Okay. And just to clarify, is there anything in the parenting plan? You expressed concerns related to the late night arrival of the boys after midnight. Is there anything in the parenting plan that specifies the children have to be in bed or at the house prior to a certain time?
Not that I believe, Your Honor.
Okay. Thank you, Mr. Bierbauer. The clerk just indicated to me that the recording system paused, so we just need to take a moment to make sure that's up and running. So if you'll just bear with me one moment, we'll get that up and going. It won't take long, and then I'll let you know when we're ready to go, and then I'll hear from Ms. Bierbauer. Okay, we're back on the record. Thank you, Madam Clerk. All right, Ms. Bierbauer, I'll hear from you. Ms. Bierbauer, I apologize for interrupting. Your audio quality is again, it's poor. You're garbled. I don't understand you. So maybe just test a little bit, make sure that it's going, that I can hear you and understand you.
Can you hear me now?
Yeah, that was more clear. I'm not sure if you made an adjustment or what happened, but that was better. Why don't you go ahead and repeat, and I'll let you know if I can't understand.
Okay, thank you. These neighbors have been harassing me for a year and a half. I am no longer with Derek Williams. He has not lived at my house since the beginning of July. Can be verified by the sheriff's department. The photos don't even show the door opening. So if he was even there, it might have been he knocked on the door or something. I don't know. But he has not seen it or talked to those children in a year and a half. I have not let that happen. I have not let my time taken away.
So, Ms. Bierbauer, if you're speaking just momentarily ago that there was no audio coming through, so I'm just concerned I may be missing something.
My phone's kicked me out of this court several times today. I'm not sure what's going on. The main fact is Derek has not been near the children. He has not even said hi to them. They have not seen him. There's no pictures of him and the children because it hasn't happened. I'm being told all these things are happening with me and Derek when I have the kids, and they're not. There would be pictures. Just getting this with going contempt hearing time after time again with no actual proof of him with those kids because he's not with them.
Could you address for me, please, on Mr. Beerbauer indicated that there was a photo of Mr. Williams on July 5th, 10:11 at night. And he indicated that was during your parenting time, your residential time, and then another time on the early morning of July 6th. Can you address that and whether the children were present and Mr. Williams was present?
Mr. Williams was not present, and the date on that was typed in by the neighbor. There's not an actual official timestamp from the computer of the video to show that that's accurate.
Okay.
Because he was not with those children, and those children are asleep by 8, 9 o'clock. They take their meds at 7.
Okay. And does Mr. Williams visit your home?
Not when I have my children.
So yes, he visits the home, but not when the children are there.
Yeah, he used to live there, but then when it was week on, week off, he moved out because of the court thing, and it's just easier with him not there at all. But the most he ever did is we used to share a vehicle, and like on the weekends I might go outside and give him keys or something, but he does not come inside with those kids or anything.
Okay. And what would you say, the past month or two, what's been the frequency of his visits to your home?
I wouldn't say much at all. We don't share a vehicle anymore. There's no reason for him to be at my house. So I have not knowingly known he's been there. Me and my kids stay inside or we're out in public. Like we're not, it doesn't make sense how they're trying to say he's there.
Okay. So during the last month and a half, how often do you think he's visited the home?
He doesn't visit the home. He might have to go get a vehicle from the front, but that would only be one. I've been telling him to stay away. I don't want near me. I don't want near the kids. Nothing.
So there were some photos. So are you indicating that Mr. Williams was not at your apartment on the evening of July 5th?
Absolutely not. He was not there.
And on the early morning, just past midnight on July 6th, was he there?
He was not.
June 7th, Mr. Beerbauer indicated that service of paperwork was served upon Mr. Williams as kind of a substitute service to be able to serve you. And the indication was that he received that. He was at the home at that time. Do you have any input on that?
That was June 27th, and I didn't have my children. That was the last week Derek lived there.
Okay. So he was inside the home, is that correct?
When I did not have my children.
So
that was probably the last time he was in the home.
When was the last time Mr. Williams was inside your residence?
It's been weeks. It's only when I don't have my kids, he might come over and hang out. That was it. He doesn't come over at all anymore.
So when was the last time he was inside your residence?
I would say over 2 weeks ago.
Over 2 weeks.
Mm-hmm.
So sometime maybe late July. Is that accurate?
Late July, first week of July, when I did not have my children.
Okay. All right. Any additional information you want to share with me?
I keep my children's safety as utmost importance. I love my children. I've been their mom, obviously, their whole lives, but I was their full-time mom also this last year. My children are my life. I would not do something to endanger them. I really would like all of this, whatever's going on with my neighbors and everything else, to just stop. I don't even want to live there. I want to move because my neighbors make me feel, I don't feel comfortable in my own home because they're always running their mouths and just causing issues. And my anxiety does not work well with it. I'm just ready to be over everything. And like I said, I am no longer with Derek Williams. He no longer lives at my residence. And this shouldn't even be being brought up anymore because he hasn't been around my children this whole time. Yes, I hung out with him when I didn't have my children. That's okay. I just will not do it when I have my children. We've never been in a vehicle with him in the year and a half. It has not happened. There's no pictures because it's never happened.
Thank you, Ms. Beerbauer. I'll hear from Ms. Height. If you have any comments.
My concerns remain, Your Honor, that this relationship seems to at some level be continuing and that the possibility of these children being exposed to Mr. Williams is concerning to me. I did note one other bit of information that on August 23rd, Mr. Williams is due to be in court before Judge Blondin on charges of possession of controlled substance and theft, third-degree theft, from something that occurred November 17th of 2023. So I am concerned for the children to have any incidental exposure to him.
Okay, thank you, Ms. Height. Mr. Beerbauer, let me ask you a follow-up question, if I may. The Vivint camera images, how do you know there are the dates on the dates which you told me they were captured?
Those are on they're time stamped on the camera when it's sent to me. I've got other ones that have those, that has a timestamp on them. I'm just trying to find them. I think I have them saved on my computer. But yes, she sees him come in and out and she sends him to me within 24 hours. And it is also still his registered address.
Okay. All right, thank you. All right, so the parenting plan that was issued on September 2023 lays out some specific concerns and specific prohibitions related to Mr. Williams. As I indicated before, section 14.2 says the children are to have no contact with Derek Williams or be present at the mother's residence during any of the mother's on-duty parenting time. So anytime that it's her residential time, he's not to be at the residence. So the information we have is that there was, on June 27th, the indication was that Mr. Williams was at the home. The children weren't present, but he was at the home. He received service of documents at Ms. Beerbauer's home. There's a photo of Mr. Williams on July 5th, 10:11 at night. Then also the next day or early morning about midnight. And this is during a time frame that the children were with Ms. Beerbauer during her summer week, the July 5th to July 12th. I asked Ms. Beerbauer a number of questions about Mr. Williams and presence at the home. I find her answers not to be credible, and I find that he has been present at the home while the children have been in the home. So I'll make a finding of contempt that provision of 14.2 was violated. So then the request by Mr. Beerbauer is to suspend all visitation and require mental health evaluation and a hair follicle test. I think what I'm going to do at this point, rather than suspend all visitation, I'm going to make it professionally supervised visitation for 2 hours a week, Wednesday from 3 to 5 p.m. If it can be on a different date, a different time, I'm fine with that. Kind of the base level would be Wednesday, 3 to 5 p.m. If that doesn't work out, then it could be any day of the week, has to be professionally supervised, and Ms. Beerbauer would bear that expense of the professionally supervised visitation of the children. Any questions from the parties?
My question is, Your Honor, is the children are with her right now. They are scheduled, they are with her till Friday at 5. I picked them up at 5. What's your ruling on that? let them go until Friday, or
No,
why
there's
committing?
been a finding of contempt, and so there need to be exchange of the children. I don't want it to be terribly abrupt for the children. I'm thinking maybe tomorrow afternoon, the exchange could occur.
And I'm good with letting her have them till Friday at 5 because I don't have a babysitter lined up.
Okay, I'm fine with that too then. So the exchange of the children will occur on Friday at their normal exchange time. I'm going to write a bench order that makes that finding of contempt and setting the professionally supervised visitations to occur.
Okay.
Your Honor,
Oh.
could I ask a question?
You may, but hold on one moment. The clerk indicated the recording system is again having an issue. I'll let you know
Okay.
once it's
Okay.
finished, and then you can speak and share. All right, Ms. Height, ready?
Thank you, Your Honor. I'm pondering the supervised visitation. Typically, we think of it as happening probably at Reconnecting Families here in Longview.
Okay.
That requires those boys to have a nearly 1 hour drive on each end of a 2 hour visit. I don't know specifically what would be available in Cathlamet for them as far as what services are available there for supervision, but I wondered if you thought it would be appropriate to try to find something closer to their home.
Seems reasonable. I mean, my intent is not to terminate any visitation with the mother. My concern relates to Mr. Williams. I think Mr. Williams is there. He's frequenting the house.
Yeah.
And I think there's an effort to conceal that, and I just don't trust that that's going to cease at this point. And so I'm trying to make sure that the children are protected, and that mom has time with them under controlled circumstances. If there can be a way that there can be those full hours, or those 2 hours could be spent with less travel time for the children, that seems like a good thing. That this isn't the children's doing. This is the mother's doing, and so we need to. So if that could be accommodated, that'd be. I agree with that.
Okay, thank you.
So I'm
I
just
have
gonna go ahead.
Question, Your Honor. So are you ruling on like the hair follicle test that needs to be done before she can be seeing the children, or?
Yeah, good question. The issue as far as the mental health evaluation, I'm going to hold off on that and not order that. The hair follicle test, I understand where you're coming from in that you're asking that a hair follicle test be issued because Mr. Williams is frequenting the home, and oftentimes people that are bring those that they've spent time with into that same circle and into those addictive behaviors. With the presence of a professional supervisor, the professional supervisor is not going to allow visitations to move forward if somebody's obviously under the influence. So I'm going to hold off on the hair follicle. I think that there's maybe some basis to order, but at this point, there's just not enough. So give me just one moment to finalize this order and I'll read it to you. Thank you for your patience. The order reads, the court finds respondent in contempt for violating paragraph 14.2 of the September 28, 2023 parenting plan by having Derek Williams in her home during her residential time on July 5th and July 6, 2023. The court hereby alters the September 28, 2023 parenting plan, allowing professionally supervised visitation, cost paid by respondent, to occur 1 time per week for up to 2 hours. So I'll sign that. If any party needs a copy of this order, you can certainly check with the clerk's office and get a copy for your records. Any questions from
Will the supervised lady that does the visits, will she reach out to me on
Generally.
schedule? Because like I said, school starts up the 27th, and it just dawned on me, they go to school till 3:30 on Wednesdays.
Mhm.
And then, but they have Fridays off. So if she'll reach out to me, I can give her the schedule and a day that will work.
Yeah, I think that's generally, there needs to be coordination between the parties for the scheduling of the visitation. And Ms. Height, do you have any comment on that?
I'll do some research and see what I can find out about something that's available in that area.
Okay, that's very kind of you. I appreciate that. Ms. Beerbauer, do you have any questions?
Yes. Admired on Reddit, and then I just need to Kathleen and figure out how to get my 2-hour visitation every week.
I apologize. I understood the last portion of what you said, but the first 2/3, it was garbled. If you could repeat that, please.
I'm okay to have to
Oh, I apologize. Again, it's garbled and it's unintelligible. If you could maybe make some adjustment to your phone and then try again.
How about now?
A little bit better. We'll
Yeah.
give it a shot.
So I'm able to bring my children to the meeting spot for Friday at 5 and then an hour every week supervised visitation.
I think you said that the exchange would occur Friday at 5 p.m. and then thereafter there'd be a 2-hour professionally supervised visitation for each week following. Yes, that's exactly correct. Any additional questions, Ms. Beerbauer? I apologize. I wasn't able to hear your question.
No more questions. Thank you.
Okay. All right, then that'll conclude the case or the matter for today. Any final items from any party? Okay, hearing none, that'll conclude the case. Thank you.
Thank you, Your Honor.